Section 65A provides that the trials for the offenses of murder, attempt to murder, abetment of murder, or conspiracy to commit murder shall be held without a jury. In these cases, there is no discretion given to the judge. Trial without a jury will be mandatory. Section 65B provides that in any other criminal case that's triable on indictment before the Supreme Court, the prosecution may apply to the judge for the trial to be conducted without a jury on any of the grounds listed in subsection 2 of that section. Those grounds include the danger of jury tampering or the intimidation of jurors or witnesses, a criminal gang element, or the complexity or length of the trial. An accused person may also apply to the judge for trial without a jury on the ground that in view of the pre-trial publicity attracted by the case, he is unlikely to have a fair trial with a jury. The section further provides that the judge shall hear and determine every such application in the absence of the jury, and that his decision would be final. No appeal shall lie against his ruling, either granting or refusing the application for trial without a jury. This is to ensure, of course, that the trial is not held up pending interminable legal challenges. Now, Section 65C provides that, unlike a jury, a judge shall give a written judgment stating the reasons for the conviction or acquittal of the accused person. This section also provides that an appeal shall lie to the Court of Appeal against the decision of the judge convicting or acquitting the accused person. Section 65D provides for the powers of the judge where a trial is conducted without a jury. In other words, the judge would have all the powers and authority which he would have had if the trial had been conducted with a jury. And Section 65B merely makes consequential provisions for the construction of references where a trial is conducted without a jury. The provisions have been adapted from the UK Criminal Justice Act 2003 and the Criminal Procedure Amendment Bill 2011 of Trinidad and Tobago. The oppositionists have already been out there trying to campaign against all that we're doing, and one of their favorite targets is this new piece of legislation now that provides for trial without a jury. Now, Mr. Speaker, in the bill I introduced earlier to amend the Constitution, we're providing for trial without a jury. We don't think we have to, because nowhere in the Constitution as it currently stands is there anything that suggests that trial by jury is a fundamental right. But we're doing that out of an abundance of caution. A couple of things. Again, if there is anyone among us or anyone out there who does not admit that jurors are easily intimidated in the current climate, such a person is being obtuse, or worse, deliberately malicious. Look at the question of murder cases. All you need is for one person not to agree. 12-member jury, 11 may say guilty. One person says not guilty, and that's it. You can't convict. And it is the easiest thing in the world for the criminals to either buy off somebody on the jury or, and this is what is far more common, intimidate somebody on the jury or threaten the family members of somebody on the jury. So while trial with a jury is an ancient practice, the truth is, Mr. Speaker, that in modern times and in a society such as ours, I have absolutely no hesitation in saying that the time to end this trial by jury has come. We are in a fight for Belize against the criminals. And a measure such as this that would take away from them this ability to intimidate jurors is absolutely necessary. Those that are complaining have said, oh, well, this is most unusual. It happens nowhere else in the world. That is complete nonsense. More and more in the Commonwealth of Nations to which we belong, countries are moving away from trial by jury. I thought it important for the purposes of the introduction this morning to disclose to the House and to the nation some of the countries that have done away with jury trials altogether in criminal cases. We're only saying no jury trial in murder, attempted murder, abetment, and so on. In any other criminal case, you have to apply. I am telling the House now, you and the House, Mr. Speaker, about countries where jury trials have been abolished altogether. In the Far East, all Commonwealth countries, all countries that belong to the Commonwealth of Nations as we do. India, done away with jury trials. Pakistan, Bangladesh, Solomon Islands, Papua New Guinea, Fiji, Vanuatu, Singapore, Malaysia. In Africa, Botswana, Kenya, Kiribati, Lesotho, Malawi, Mozambique, Namibia, Nigeria, South Africa, Swaziland, Tanzania, Uganda, Zambia. So there is nothing peculiar about what we're doing. Even in the UK, they don't have it as an automatic provision in certain cases, but there is provision for trial without a jury in fraud cases or cases where there's a danger of jury tampering. The first juryless trial in the UK was held on 31st March 2010 when 4 persons were found guilty of armed robbery. In Mauritius and Sierra Leone, a provision for trial without a jury for certain offenses at the discretion of the Director of Public Prosecutions. Even in the Commonwealth Caribbean countries, there is a move afoot. Trinidad and Tobago has tried it, but there is opposition and they don't have the majority in Parliament that this government has. And so the matter has been delayed. There is a lady, Professor Rose Marie Antoine, who has written a celebrated treatise, Commonwealth Caribbean Law and Legal Systems. And she makes the point that jury trials are of diminishing importance, diminishing relevance in a modern day context where our small societies are under this relentless assault from the criminals. So this is one, Mr. Speaker, that we make absolutely no apologies for. And nobody can claim that the accused is any less protected. Trial by a judge, a trained lawyer with experience, whose entire philosophical disposition is to protect and safeguard the rights of accused persons. So it's not as though in trying to ensure that the system is not gamed by these people, we are putting them in a situation in which they have no rights. No, they're going to be protected by the judge sitting alone. But it is far less easy for them to intimidate the judge, to get to the judge, than it is for them to get to one member of a jury.